The next case is in re EH and AH. It looks like the appellant waived oral arguments, and we have the appellee, attorney Prue for the appellee today.
Correct, Your Honor.
So, as you know, the arguments are being recorded. When you present your argument, please introduce yourself, keep your voice up, and remain behind the podium. You should not use the names of minors and victims during your argument. Please refer to them by initials or terms like the child. You will just have a straight 15 minutes to present your argument.
All
And
right.
you may proceed when you're ready.
Thank you very much. Good morning. My name is Lee Prue, and I represent the Lorain County Department of Children's Services in this matter. This case centers around the best interests of two children, one of whom was savagely injured by the two people that would be most expected to provide them with a safe environment, namely their mother and father. The maternal grandmother in this case moved to intervene in the case in order to be considered for legal custody of the children. But though she intervened, she has taken minimal action to demonstrate that she would be a superior choice for legal custodian of the children, over the couple that was actually awarded legal custody, namely CJ and CHJ. The manifest way of the evidence, the case shows in part, for example, the maternal grandmother attended the hearing to determine legal custody, but she did not provide any evidence during that hearing to demonstrate why she should be considered for legal custodian. Objections were filed to the magistrate's decision in that matter, but they were not filed by her. They were filed by the father. She did not even bother to participate in the hearing on the objections to the magistrate's decision. And she also did not file this appeal. This appeal was filed by the father. In short, the maternal grandmother is not committed to this process. This case starts with the tragic events that initiated the case in the first place. It was on or about June 9th, 2022, when AH, who was a 7-week-old baby at the time, was taken to the hospital. She was taken to the hospital because she'd been crying all day long. She'd been twitching, and her mother brought her to maternal grandmother to question whether or not anything ought to take place with this baby. And eventually, maternal grandmother decided that it would probably be best for a crying all day long baby and a twitching baby to be taken to the hospital.
What do you mean by eventually?
Well, she didn't do it right away. It's not as though she received the baby, saw the baby, and said, oh, this baby is twitching and it's been crying all day long. Get her to the hospital.
What's in the record with respect to after the grandmother first saw the baby and the time in which the grandmother recommended that the baby be taken to the hospital?
The record reflects that she told the mother to take the baby to the hospital.
Well, okay. But right away?
I don't know. To be honest, I think it was probably the end of the day. I think it looked to me like she was rather nonchalant about it.
So what does the record reflect?
The record reflects that the maternal grandmother told the mother to take the baby to the hospital. I don't have the impression from the record that it was intended that she take the baby immediately. I believe that that baby had been crying all day before the mother made a determination, the grandmother or the maternal grandmother made a determination the baby should be taken to the hospital.
My understanding was that the mother had sought out grandmother for guidance.
That's correct.
And when she sought out grandmother for guidance, grandmother said, you know, bring the baby to me or I come to him or whatever.
Right.
And then the grandmother said, take him to the hospital.
Right, well, it's not as though the grandmother herself rushed the baby to the hospital. I mean, this baby was crying all day long and had been twitching.
Well, she may not even know all that. Is there anything in the record about that?
I believe the record indicates that the grandmother saw the baby crying and twitching. And that's what I
know
was
that
wondering.
because everybody agrees because grandma was the one who said take him to the hospital.
Right, exactly.
Okay.
There wasn't necessarily just the mother's testimony to that effect. I believe the grandmother saw that. Now, when the baby did end up going to the hospital, it was determined that the baby had a skull fracture. The baby had multiple brain bleeds, and the baby had multiple subdural hemorrhages behind both of her eyes. That kind of action does not take place toward a 7-week-old baby unless there's abuse taking place. At that point, it was recommended to take AH, who was a 7-week-old baby, along with her sister EH, and move them out of that house for safety purposes. And in that process, they were moved to the residence of the person who's now been given legal custody, namely CJ, who was a friend of parents at the time. In the process of this case, maternal grandmother did make it known that she wanted to be considered for temporary custody, so she did move to intervene in the case. But there was a problem right away. Maternal grandmother had to choose between her daughter and her grandchildren in determining who to support in this case. So instead of choosing her young grandchildren who had been subjected to abuse and needed to be in a protective environment, she instead chose her daughter and her son-in-law to support in that process. She said that she had no idea how these injuries could possibly have taken place toward AH. She also supported AH's parents, who also said that they had no idea how these injuries could possibly have
Well,
taken place.
isn't that's what's at issue in a juvenile case? There's an injury and then is it abuse? So is the feeling that you think that there was not abuse a problem?
No, and the reason, Your Honor, that I don't believe that's a problem is because during the dispositional hearing, it was disclosed that the father was charged with felonious assault and pled guilty to a felonious assault, and he was also charged with 2 counts of child endangering, and he also pled guilty to 2 charges of child endangering, and mother also pled guilty to a count of child endangering.
So you're saying that grandmother continued to profess their innocence even after they had pled guilty to the offenses involving the baby?
Not only did she continue to plead their innocence, father himself, when he testified during the hearing, had said, I didn't do anything to that baby.
I understand, but I wanna make sure and we will go through the record in great detail, but the record reflects that grandmother continued, she didn't testify, right?
No,
Well, how do we know that she continued to, say that the parents weren't responsible after they pled guilty?
that was the testimony of the social worker.
And she had said to the social worker, I still don't believe it even though they pled guilty?
That's correct. And that's, you'll find that in the record as well. And I think that it's really important that this court understand that grandmother never did testify. If you want to be considered as a legal custodian, why would you not go in front of the court and tell them every reason that you have that you're the more appropriate custodian than the people that Lorain County Children's Services thought would be appropriate as legal custodian in this case? If you're really interested in fighting for the custody of these children, this is the kind of action you would take. And during the hearing, I think it should be mentioned, again, she obviously didn't testify. She did not distance herself from them and make assurances to Children's Services during the whole course of the process of the case, that if the children were in her custody, she would keep them safe and she would make sure that she would keep them away from these parents. I can understand to some degree the fact that she's got a daughter in all of this. She also has grandchildren in all of this. And she knows that one of those 2 people, and now we understand that the father had pled to this, caused not necessarily just a minor injury, skull fracture, hemorrhaging, subdural hematosis behind the eyes, things that make it really obvious that this child was subjected to an angry experience of abuse, possibly more than one. This is just the one time that she ended up going to the hospital. That's a very serious injury to take place toward your grandchildren. I would think that if you were interested in being a legal custodian, you would do your very best to keep the children out of that kind of a situation. It also turns out that mother became pregnant during the course of the case. And grandmother didn't think it was necessary to tell Children's Services. And she had testified that she spoke to the guardian ad litem with regard to this. Guardian ad litem said, why didn't you tell Children's Services that your daughter was pregnant? And she said, well, they didn't ask, so I didn't think it was necessary to tell them. Now you have a situation where the daughter is living with somebody who's engaged in a skull fracture against one of her other children, now carrying another one of their children. And maternal grandmother rather, did not think it was necessary to tell Children's Services about the pregnancy and keep that baby potentially safe. In fact, maternal grandmother filed for custody of that baby right away within 3 days after the baby was born.
Did the trial court make a determination on best interest of the child in terms of legal custody vis-a-vis grandmother or vis-a-vis the parents?
Vis-a-vis grandmother. Because that's the reason that the case went to trial in the first place. The objections, or the hearing, was on grandmother's motion to intervene in the case, and then her motion for custody, because she did actually file for custody. She filed for legal custody for the children. The father never did.
She did, but it wasn't the hearing, it was this dispositional hearing?
Right, it was a further dispositional hearing to determine legal custody. I mean, this wasn't a permanent custody hearing, it was a further dispositional hearing to determine legal custody. At
So,
that point-
so if it's a dispositional hearing, then the court needs to make a best interest finding in terms of the disposition with the grandmother's motion for legal custody pending.
Correct. And the
I
court
just-
did so.
And I know that there's a whole lot in there about whether it's in their best interest that the parents be their legal custodians
Mhm.
continued forward. I'm not sure in reading the order what the best interest determination is with respect to the children and the competing motion for legal custody.
Okay, well, for purposes of understanding what is necessary to determine best interests, as you probably have read in my brief, and as I'm sure all of you are aware, in the state of Ohio, there's no actual legal test to determine the best interest or to determine the grant of legal custody. It is required, as has been said, that the court has to look to the best interest of the child, and there are factors within section 2151.414D which are necessary, are imperative to be considered in a permanent custody case, but are also instructive for a legal custody case that make a determination of what best interest relevant factors are. And they are, for example, I think this is probably one of the more challenging cases. They are, for example, the interaction and the interrelationship of the child with the child's parents, siblings, relatives, foster caregivers, and out-of-home parent providers. It's difficult to determine exactly what kind of relationship they had with the parents. They didn't have any of a bonding experience with the parents because they couldn't be interacting with them. But there was testimony, and there's plenty of testimony in the record stating that they have a strong bond with CJ and CHJ and their children, which is where they are currently. The next factor is the wishes of the child. Obviously, you can't determine the wishes of a 7-week-old baby, or I realize they're a little bit older at this point, and I realize that EH is maybe about 18 months or so older than her sister, but they're way too young at this point to really express their wishes in a meaningful manner. The next factor is the custodial history of the children, including whether or not they've been in temporary custody in any children's services agencies within what would be considered a 12-month period or a consecutive 12 months of a 22-month period, which is usually the standard for permanent custody. There hasn't been a situation where these children have been in permanent custody, so that particular factor, or has been in temporary
Counsel,
custody.
let me ask you a question, going back to grandma and legal custody. Did she file a statement of understanding?
No, she didn't file a statement of understanding. The
Could
parents,
the court even award custody to her without that statement of understanding?
no, they can't.
Yeah.
And the statement of understanding was issued on the record to the caregivers, to CJ and CHJ. They both, on the record, received the statement and affirmed it.
Okay, let's clear this up. So when we first have the agency promoting, one of the individuals, and we have a statement of understanding with respect to, I don't know which of the two, but, and then the court says to the other parent, did you just hear everything she attested to? And the other parent said, yes, I do, I agree with it.
Mhm.
So are you saying that there's a statement of no statement of understanding whatsoever in the record from grandmother, but a statements of understanding in the record for both of the legal custodians?
I don't know if there's a statement of understanding with regard to CHJ, but I don't believe he made the motion either.
But he was awarded legal custody.
Correct. And given the fact that it was done during this hearing, and given the fact that he had the opportunity to hear what was being said, and he had the opportunity to affirm them in front of a judge, I think that would qualify as an efficient statement of understanding for purposes of awarding him legal custody. In determining the assignment of error here, the question that was brought before this court is whether or not the juvenile court's decision was against the manifest weight of the evidence. Given that the responsibility for the court is to determine whether or not legal custody was appropriate and take the weight of the evidence that was provided to the court and make a determination based on the weight that was provided as to whether or not the weight is able to withstand the objection here, I think it's beneficial for this court to recognize there was really no evidence provided by the grandmother as to whether or not she would be an appropriate legal custodian. It's challenging, I'm sure, for this court to figure out exactly what to weigh, because the appellant really didn't provide any evidence as to why she would be a better custodian. We did have the parents expressing their displeasure over the legal custodians who had custody at the time, but we also had evidence that they were in a safe environment, that they had bonded with the caregivers, they had plenty of food, that they had beds to sleep in, and that both these caregivers understood the importance of legal custody, the legal requirement for legal custody, and had in fact signed a statement of understanding that was required for them to sign when they accepted legal custody.
And you're out of time. So if
Okay.
you could wrap up in the next 15 seconds, we appreciate that.
At this point, the Department of Children's Services would ask that the court affirm the trial court's ruling. Thank you very much, Evan.
Thank you for your presentation. The court will take this matter under advisement and issue a ruling in due course. On the day the decision is released, it will be mailed to you by the clerk's office. Also, the opinion will be located